Hello everyone, I'm delighted to be here today with Connie Lau of Perun Consultants and Calvin Ho, a partner at Charltons, to talk about financial distress and restructuring issues for Hong Kong listed companies. Today's webinar is the third of 3 on insolvency and restructuring. In the first webinar, we talked about how to identify financial distress in corporates, as well as practical and legal considerations to deal with these difficult situations. In the second webinar, we covered different restructuring options, including debt restructuring, capital injection, and court-assisted restructuring. Today, we're focusing on different restructuring mechanisms and the regulatory requirements for Hong Kong listed companies. Before we start the webinar today, I'd like to say a few words about the two speakers. Connie Lau has over 20 years of experience in restructuring and insolvency work, gained in a Big Four accounting firm. She started her career with financial restructuring engagements and assisted bank creditors in the restructuring of listed companies since the early 2000s. She was the senior engagement leader in the liquidation of Lehman Brothers. She's currently the managing director of Perun Consultants, a boutique financial services firm with offices in Hong Kong and Singapore, focusing on high-quality services in the area of forensic accounting, corporate advisory, restructuring, turnaround, and liquidation appointments. Calvin Ho, one of my partners at Charltons, has over 15 years' experience in corporate finance and commercial transactions. He frequently advises on takeovers and restructurings, in particular in relation to Hong Kong listed companies. So now I will be kicking off today's webinar. In webinar 1, we discussed the duties of directors of Hong Kong private companies. And as you may recall, these include, firstly, fiduciary duties to act in the best interest of the company and its shareholders as a whole, and where the company approaches imminent insolvency or is faced with a real risk of insolvency in the interests of creditors as a whole. Secondly, a duty to act with such care, skill, and diligence that would be exercised by a reasonably diligent person acting as a director, with reference to the specific knowledge, skill, and experience of that director. For a company listed on the Hong Kong Stock Exchange, directors are expected, both collectively and individually, to fulfill fiduciary duties and duties of skill, care, and diligence to a standard at least commensurate with the standard established by Hong Kong law. They're also required at the time of their appointment to provide an undertaking to the stock exchange to comply to the best of their ability with the listing rules, as well as to procure the relevant listed company to comply accordingly. So directors are expected to gain familiarity with the listing rules, as well as laws and regulations applicable to the listed group, and would quite often undertake directors' training upon their appointment and from time to time as desirable to ensure that they can properly discharge their fiduciary duties, as well as duty of care as directors. If necessary, directors should also seek the advice of legal counsel or compliance advisors. A breach of directors' duties would be a breach of the listing rules and the relevant undertaking provided by each director to the stock exchange, and could cause them to be disciplined by the stock exchange through private reprimand, public censure, or statements involving criticism, and or reports being made to the SFC or other regulatory authorities, including any offshore authorities, pursuant to which the SFC has entered into cooperative arrangements for exchange of information under the IOSCO Memorandum of Understanding framework. The SFC may impose various orders against directors, including, for example, cold shoulder orders, which deprive the director of access to securities markets, cease and desist orders against further breaches, and orders for restitution and or damages. I'll now pass to Calvin to discuss some listing rules which are particularly relevant to directors of a listed company when the company is in financial distress or when its financial condition is deteriorating.
Thank you, Julia. So under Part 14A of the Securities and Futures Ordinance, a listed company must disclose unpublished price-sensitive inside information by way of an announcement as soon as practicable upon becoming aware of the information. In this regard, inside information is deemed to have come to the knowledge of a listed company if the information has or ought reasonably to have come to the knowledge of its officers in the course of performing their function as officers. Quite often, price-sensitive inside information may arise from actions of the listed group itself, for example, from devising or implementing restructuring plans. In other cases, it could be caused by external factors which impact its business, operations, or financial conditions. For example, business may be affected by imposition of sanctions by foreign governments or restrictions brought on by pandemics such as the COVID-19 or downgrading of ratings of its debt issued by rating agencies. In either case, directors must make a timely and informed decision as to whether an announcement should be made. If the information is not generally known to the market, and they form the view that the price of the company's securities will be affected if disclosed to persons who are accustomed or likely to deal in the securities of the company, then announcement of the information would become necessary. For reference, the guidelines on disclosure of inside information published by the SFC provides a non-exhaustive list of common examples of events or circumstances where a listed company should consider if a disclosure obligation would arise. Some of these events relevant to distress situations include changes in financial performance, changes in financial condition, or expected earnings or losses of the company, as well as any proposed restructurings and reorganizations. One particularly common situation, which may warrant directors' attention, especially when a company may be in distress, is upon the receipt of financial results. This may be in the form of advanced draft of audited accounts or monthly management accounts. In considering whether the financial results contained in these accounts may warrant the publication of an announcement, such as a profit alert or a profit warning, the directors should make an assessment as to whether there is substantial difference between the results in which the market might predict and actual results of the company. If such difference is significant, then it is likely an announcement should be made. In their considerations, directors should have reference to what has already been published to the market to date, such as past results or forecasts that has been issued, or they should also consider what profit projections or analysis has been published by credible analysts or journals, as well as the other information that is available in the public domain. For example, they may wish to consider the performance against competitors or peers, which may be affected by similar circumstances. And they may also need to consider the market sentiment relating to the listed company in general. So the SFC has not today provided any bright line tests as to what percentage change in financial performance may be taken as material or significant. However, an insider dealing tribunal case, it was stated that whilst the accounting profession, an upward or downward movement of 5% or more may be considered material, it would be dangerous to lay down any hard and fast rule for Part 14A purpose. And this is because each company is different and the same information may have different impact on different companies due to their difference in size, nature of business, or exposures. Therefore, companies should consider specific circumstances affecting the listed company in making decisions. A company may potentially defer disclosing inside information in certain prescribed circumstances. This includes where information relates to a transaction that is still being negotiated or remains an incomplete proposal subject to finalization. The condition is that adequate measures should be in place to preserve the confidentiality of the information, and confidentiality has in fact been preserved. For example, a company contemplating debt restructuring or refinancing with creditors may possibly defer disclosing such facts prior to entering into binding commitments with creditors if non-disclosure undertakings have been entered to preserve confidentiality up to the publication of the announcement. While the SFC has not issued any formal guidance as to when a transaction will become a complete proposal, generally the obtaining of broad approval for the transaction or the entering into of any binding commitment may cause a transaction to be complete. Therefore, we would generally advise that such actions be taken after trading hours to avoid the necessity to suspend trading of the company pending the announcement. Persons in possession of price-sensitive inside information of a company must refrain from dealing in securities of the company prior to its publication. Any dealing of securities of the company or procuring of others to deal in securities of the company whilst in possession of such information may amount to insider dealing. And this is a very serious offence and may cause relevant persons to be subject to sanctions and in more serious cases to imprisonment and substantial fines. Therefore, persons who receive accounts of the company on a periodic basis, such as directors of the company, or its controlling shareholders who may receive accounts for consolidation purposes, must be particularly careful against insider dealing. To avoid insider dealing from being committed, effective arrangements should be put into place to ring-fence price-sensitive information to those with a need to know. This may involve setting up physical barriers or security measures around sensitive information. Having insider dealing policies in place and staff training may also assist to mitigate the risk of unintended leaks or disclosures. For directors of a listed company, the restrictions on dealing extends to certain prescribed periods leading up to and on the date of publication of financial results. Such periods, commonly referred to as blackout periods under the Model Code, are shown in the slide. The restrictions extends to the creation of security or granting of any options or rights over shares of a listed company by a director or any company controlled by the director. Therefore, in the context of a restructuring, proposals involving the creation of security or rights over shares of directors or any investment vehicles used by them to hold shares in the company must be implemented outside of these blackout periods. I would like to point out that the restrictions apply to any posting of top-up collaterals over shares of a listed company that may have resulted from change in loan-to-value ratios caused by a reduction in share price of the company. And this is quite often overlooked and may lead to a director having to choose between breaching the Model Code or the security covenants contained in the relevant loan facilities. To preempt the necessity to obtain necessary waivers from the stock exchange for such dealings, the relevant terms of the debt financing or restructuring should be negotiated to provide for any dealing, such as any pledge of top-up collateral, to be postponed until after lapse of the blackout periods. So that concludes our discussions on regulatory obligations that the directors of a listed company should be particularly aware of during periods of distress or when contemplating various forms of debt or equity restructurings. I'll now turn to talk about restructuring options and mechanisms for listed companies. So when a company is in financial distress, quite often its share price underperforms, and this may lead to trading at a significant discount to net asset value per share. Impacted by COVID-19 in the last year or so, we observed that the share price of some listed companies had dropped so significantly that their cash position exceeded their market capitalization, that they had enough cash to possibly carry out a share buyback offer. Such underperformance of share price or negative results of a listed company may make the relevant company not investable by asset allocators and investors, and that an inability to raise equity capital to support its growth and strategies may hamper its overall goal of value maximization. It may also cause any investment terms that may be negotiated in any proposed restructuring plans to be based on unfavorable valuation given the suppressed market capitalization. It may also increase the cost of borrowing and make any restructuring proposals or steps involved much more difficult to execute. We'll discuss further in this webinar that in distress situation, it's more likely that any asset injections or disposals would require the obtaining of independent shareholders' approval, which may or may not be forthcoming. This is particularly an issue if PR work had not been properly conducted and investors have a different view of the future path of the listed company than management based on misinformation. An underperforming share price may also lead to weaker liquidity or low analyst coverage, and this may make the cost of remaining public not justifiable. In such a case, privatization and delisting of the company may become an option that could be explored with a view of unleashing value and possibly assist with facilitating more drastic restructuring options. So in the last year or so, we saw an upsurge of privatization cases arising from the challenging business environments caused by social distancing measures during the COVID-19 pandemic, as well as ongoing US-China trade war. So in the next few slides, we've extracted some of the reasons for privatization cited by some companies in their privatization documents. This includes providing more flexibility as a private business for management to formulate strategies free from ongoing regulatory constraints, allowing shareholders the opportunity to avoid macroeconomic uncertainties leading to low trading liquidity of shares, the inability to raise equity and funds in difficult environments, and in some cases to facilitate mergers and business consolidations for increasing efficiency of operations. So what is privatization and what does it involve? A privatization is an offer by the listed company or its controlling shareholders to acquire shares from its shareholders to an extent it no longer has a public float. Some common methods of privatization are by way of a general offer, which typically involves the controlling shareholder making a voluntary general offer to acquire all the shares of other shareholders, or by way of scheme of arrangement, which involves a scheme being approved by shareholders and sanctioned by the court. Where the company is cash rich, then you may also consider privatization by way of a share buyback offer, and this involves the company making an offer to buy back all of its shares from other shareholders. This, however, is extremely rare in Hong Kong. So in the next few slides, we'll talk about key requirements and procedures involved in a privatization by way of general offer and scheme of arrangement, as well as a brief comparison of these two methods of privatization. In addition to compliance with applicable laws and regulations, including the Takeovers Code issued by the SFC and the listing rules, the provisions of any agreements and undertakings binding the company and its controlling shareholders must also be carefully considered. For example, loan facilities entered into by the company may contain conditions for the company to remain listed. As mentioned, a privatization by way of general offer would typically involve the controlling shareholders making a voluntary general offer to acquire all the shares of the other shareholders. The offer may be in cash or securities or a combination of both. In a privatization offer, a composite document will be sent to shareholders, and this would contain terms of the offer accompanied by forms of acceptances. It would also set out the views of independent board committee of the board, as well as independent financial advisors which are engaged to advise on the merits of the offer, as well as whether the offer is fair and reasonable and should be accepted. The offer may be accompanied by any number of conditions stipulated by the offeror, provided they are not dependent on its judgment or in its hands. Typically, privatization offers will be made subject to the condition that the offer be accepted by at least 90% in value of shares held by disinterested shareholders. In some cases, a higher threshold may be set if such higher threshold is required to enable the offeror to compulsory acquire shares of non-accepting shareholders under applicable laws. Such provisions are commonly referred to as squeeze-out provisions or compulsory acquisition rights. A shareholder who has received an offer may then choose to either accept or reject the offer during the offer period. The offer period should last for at least 21 days after posting of the offer document, or at least 14 days from any revised offer document if the offer, such as the offer price, has been revised. The privatization offer would fail if the acceptance threshold has not been achieved by the 60th day from the date of the offer document. It is possible for the offeror to obtain irrevocable undertakings from sophisticated or institutional shareholders to accept the offer. This would increase the prospect of achieving a successful privatization because their agreement to such undertaking may be indicative to the market that the offer, and in particular the offer price, is acceptable to them based on their professional assessment. So a scheme of arrangement, on the other hand, involves the sending of a scheme document explaining the terms of the scheme to shareholders. A capital reduction scheme would involve the cancellation of all issued shares of the company other than those of the offeror against payment of consideration by the offeror to former holders of cancelled shares. As a transfer scheme, on the other hand, would involve the transfer of shares of the listed issuer to the offeror. Any scheme would require the approval of shareholders in a general meeting as well as sanctions of the court in a court meeting in which shareholders may appear to make submissions. The board of the company would be responsible for drafting and dispatching the scheme document, which would, as in an offer document, include the views and advice of independent board committee and independent financial advisors as to its merits. So in this slide, we set out an indicative timetable for a scheme of arrangements. So from a regulatory perspective, a privatization scheme is required to be approved by at least 75% of voting rights attached to disinterested shares at a duly convened meeting. Further, the number of votes cast against the resolution to approve the scheme must not be more than 10% of the voting rights attached to disinterested shares. Although the 75% threshold is lower than the 90+ threshold for a general offer, the possibility of a scheme being vetoed by disapproval of a mere 10% vote makes it one of the most important factors to consider as the disapproval of major disinterested shareholders may potentially thwart the entire scheme. For example, we may recall that in the privatization of a well-known developer in 2018, the disapproval of an asset manager which held approximately 7% shareholding at the time was sufficient to cause the whole scheme to fail. For such reasons, the obtaining of irrevocable commitments from such key disinterested shareholders should be seriously considered. So some key matters to consider when deciding which method to effect a privatization are set out in the following few slides, which these will be made available to you separately, so don't worry if you don't catch it all. So a scheme of arrangement is an all or nothing type of deal where acquisitions of 100% of shareholding from other shareholders is guaranteed following the obtaining of a court sanction for the scheme. This may potentially attract predatory moves from potential bidders as it signals to the market the amount of resources the offeror is willing to commit to the scheme. On the other hand, a general offer may simply result in the offeror consolidating control over the company if it chooses to close the offer without triggering the squeeze-out provisions. A scheme of arrangement may provide the controlling shareholders more opportunity to make submissions and respond to concerns of dissenting shareholders in court or shareholders' meetings. On the other hand, such opportunities are not available in a general offer, and shareholders are requested to either accept or reject the offer based on materials provided. The timetable to a scheme of arrangement may be materially affected or restarted if certain shareholders request the scheme to be amended. On the other hand, the offeror in a general offer could revise the terms of such offer and increase the offer price from time to time during the offer period based on its gauge of acceptance level over the offer period. A scheme of arrangement is typically more time-consuming and more costly, involving court proceedings. But financial arrangements are typically more straightforward and no stamp duty is usually payable except in a transfer scheme. So in any privatization plan, there are two factors which are particularly crucial. First is the fairness of the offer price. And in this regard, the advice of financial advisors should be sought. In the following slide, we set out some factors which shareholders may typically consider in the evaluation. In many instances, however, we see that the perception of shareholders quite often trump over business fundamentals. For example, shareholders are often suspicious that controlling shareholders are merely taking advantage of plummeted share price to privatize assets in which they've invested with a material discount. They would therefore choose to oppose the offer. For such reasons, an effective PR and investor relationship strategy may be crucial to mitigate such allegations. Second, understanding the shareholder base and obtaining irrevocable commitments from meaningful or institutional shareholders may be crucial. As we've discussed, that the dissent in some cases may potentially thwart the whole scheme. However, no special deals, meaning any offers that are not made available to other shareholders, could not be reached with these investors. So in the following slides, we set out some key data concerning privatization transactions in the last 15 years or so. While it's not possible to go through this in detail in this webinar, some key takeaways are as follows. Scheme of arrangements appear to be the preferred approach, followed by general offer, whilst all tender offers have failed. Premiums to prevailing share price in successful privatisation varied materially, from none up to 150%, with an average premium in cases since the start of 2020 at approximately 40%. As expected, premiums paid in successful privatisations were higher than for unsuccessful ones. And other than in certain exceptions, the share price had been dropping at the time of successful offers were made, and higher premiums is required when the share price had been on an uptrend. Lastly, the size of the company does not seem to matter, as we saw that there were no discernible correlation between the size of the transaction and the amount of premium that would need to be paid for the transaction to be successful. So following a privatization, a company may voluntarily withdraw its listing from the stock exchange, provided then that the notice of the withdrawal of listing is contained in the relevant shareholder circular or document. After that, the implementation of any restructuring plans of the company, such as any disposal of assets or transactions with affiliated persons, would no longer be subject to provisions of the listing rules. So that concludes our discussion of privatizations of listed company as a restructuring option. In the next section, we'll talk about other potential restructuring options. So in webinar 2, we've discussed that a company in financial distress may potentially raise funds to service outstanding debt or liabilities or to finance their restructuring plans. In the next few slides, we'll talk about how this could be carried out by a listed company. So in general, there are several ways in which a listed company may raise capital from existing shareholders or from third parties. And this may include by way of a rights issue, by way of an open offer, or through the issuance and placement of securities. So a rights issue is an offer of rights to existing shareholders of the company which enables them to subscribe for shares in proportion to the existing shareholding, with those who do not participate having their shareholding diluted. In a rights issue, shareholders are issued renounceable provisional letters of allotment. And this is a document which evidences the right of the person named to have shares issued to them upon payment of consideration. Such rights, sometimes referred to as nil-paid rights, may be traded as temporary securities. As the share price of the company will likely drop due to issuance of shares into the market, shareholders may potentially be compensated from trading of such nil-paid rights in a discounted rights issue. So an open offer, on the other hand, is an offer to existing shareholders to subscribe for securities whether or not in proportion to the existing shareholding. These are not allotted to them on renounceable documents, and the rights offered cannot be traded. And in some cases, we see that an offer of notes may include detachable warrants to incentivize the subscription to the notes. So in the next few slides, we summarize some key requirements and features concerning a rights issue and open offer. So both rights issue and open offers requires the publication of and registration of a prospectus with the company registry, as they constitute an offer to the public to subscribe for securities. Rights issues and open offers are normally fully underwritten by licensed underwriters or controlling or substantial shareholders. If they are, however, not fully underwritten, then the terms of the offer would typically permit substantial shareholders to scale down their applications to avoid any general offer implications. So as discussed in webinar 2, no shareholders' approval is normally required if the issue or offer is granted to shareholders pro rata to their shareholding. If this is not offered on a pro rata basis, however, shareholders' approval would be required, and this may be by way of obtaining a general or specific mandate. As a special rule, the obtaining of shareholders' approval is required if the issued share capital or market capitalization of the company will be increased by more than 50% as a result, taking into account any rights issue, open offers, or issues of other securities attached to rights granted in the preceding 12-month period. The issuer can make arrangements to dispose of rights or shares not taken up through excess application forms to existing shareholders, provided that any unsubscribed shares must be allotted on a fair basis. In a rights issue, excess shares may also be sold to the market for the benefit of existing shareholders to whom the rights shares are offered. Lastly, the offer must be open for at least 10 business days, but usually not more than 15 business days. So a typical timeline for a rights issue, assuming that no general meeting for shareholders' approval is required, is set out in this slide. So in addition to rights issues and open offers to existing shareholders, a listed company may also raise funds by issuing securities, including shares, straight or convertible bonds, notes, and other debt instruments to third parties. For such purpose, they may engage investment banks and/or placing agents to assist with the placing of the relevant securities in return for a commission. Such methods of raising funds and applicable requirements has been discussed in some detail in webinar 2. So an interesting debt instrument that may be issued is convertible bonds, and this may be considered by sizable or reputable issuers with material assets, but which are encountering temporal cash flow issues. As the name implies, these bonds are perpetual in nature, and as such, they are typically treated as equity for accounting purposes. The fact that this would not increase the relevant company's debt ratio makes it an attractive alternative to other debt instruments. Perpetual bonds are usually redeemable at the option of the holder after a pre-agreed term, and its coupon rate may be stepped up after a certain number of years to compensate for the associated interest rate risks. Debt securities may also be offered to the public and professional investors under Hong Kong listing rules, although offers to retail investors are relatively rare. Quite often, the listing and offering of debts are underwritten by syndication of banks and financial institutions. We will not go into detail the requirements for listing debt in this webinar, but compared to a listing of equity, the procedures are relatively more straightforward. A listing application is required to be submitted, and this must be submitted together with a one-off listing fee as well as a listing document. The listing document does not constitute a prospectus if the offer is limited to professional investors, and would only need to contain such contents the professional investors expect it to contain. So some typical contents are set out in the slide. If the debt securities are convertible into shares, then the issue and listing of relevant shares must also have been validly authorized. The listing application will be processed by the stock exchange within 5 business days, and in the absence of any novel or unusual features, typically listing approvals are in practice granted within 1 to 2 business days. So in addition to raising funds, if it's believed that the financial distress of the company was caused by unprofitable or underperforming business lines, then it may also consider reducing its diversification and refocusing its business on core competencies through the disposal of business or assets. Such disposal of business or assets will constitute a notifiable transaction requiring the company to comply with requirements of Chapter 14 of the listing rules. The requirements that will be applicable to a listed company will depend on the materiality of the disposal to the listed company from the perspective of assets, profits, revenues, and market capitalization. This is measured by prescribed financial tests in the rules, and is expressed as percentages resulting from relevant calculations of ratios as set out in the following 2 slides. So in this slide, we set out categories of notifiable transactions which may be applicable based on the materiality to the listed company. In the context of a disposal of assets or business, the relevant categories include disclosable transactions, major disposals, and very substantial disposals, depending on the materiality of the transaction. So the following slide is a summary of relevant requirements which are applicable to these transactions. Generally, all these transactions will require the notification to be made to the stock exchange, submission of a size test calculation, and the publication of an announcement concerning material terms of the transaction. A suspension of dealing or trading pending publication of the announcement is required if the transaction was entered during trading hours, and therefore would normally generally advise clients to enter or approve the entering into of notifiable transactions after trading hours. For major disposals and very substantial disposals, it will be necessary to obtain shareholders' approval in the general meeting, where persons with a material interest must abstain from voting. A circular must be dispatched to shareholders, and this must include contents prescribed by the rules, which will include recommendations from directors as to how shareholders should vote. Details of gains and loss that are expected to accrue from the transaction details of counterparties and their independence, amongst other particulars. For very substantial disposals, the circular must also include financial information relating to business, companies, or any revenue-generating assets being disposed of, and this will need to be reviewed by accountants and auditors. So the notifiable transaction rules we've just discussed will apply also to any acquisition of assets or business that may be involved in a restructuring proposal. So quite often, a restructuring plan may also involve transactions to be entered with persons connected with the listed company. For example, the making of shareholders' loans to a listed company, any pledge of shares of substantial shareholders as part of any debt restructurings of a listed group, or the acquisition or disposal of assets involving substantial shareholders. These transactions will be subject to the requirements of Chapter 14A of the Listing Rules, which are designed to mitigate the risks of persons affiliated with the listed company from taking advantage of their position without regard to the interests of public shareholders. The listing rule sets out categories of persons who will be considered or deemed to be connected with the listed company, and these include directors and substantial shareholders who hold 10% or more voting rights in the company, as well as their respective associates. By definition, these associates include spouse, children over 18 years of age, as well as companies controlled by any of them individually or collectively. Other persons who may also be considered as connected persons are set out in slides, which we won't go into detail. I would like to point out, however, that the stock exchange has the power to deem any person as connected persons if they consider it appropriate to do so. So the main requirement applicable to conduct transactions includes obtaining of independent shareholders' approval in general meeting following a dispatch of a circular. The circular must contain the views of the independent board committee of the company as to whether the transaction is fair and reasonable and in the interest of the listed company and its shareholders. For such purpose, an independent financial advisor must be appointed to advise the committee. The financial advisor would typically look at the market and industry comparables, informing their view as to whether the transaction is in fact reasonable and fair. So certain connected transactions are, however, exempted from fully or partially complying with requirements of Chapter 14A. This includes de minimis transactions, where the size of the transactions is immaterial to the listed company, the provision of financial assistance by a connected person on favorable terms for the listed company, and acceptance of rights under rights issues. So having now considered some private restructuring options which a listed company may consider and the associated regulatory considerations and requirements, I will now pass to Connie to discuss some formal restructuring options which a listed company may consider involving courts, scheme of arrangements, and light touch provisional liquidation.
Thank you, Kelvin. Let's have a quick recap on the statutory framework available in Hong Kong for listed companies to utilize when undergoing a restructuring process. As discussed in Webinar 2, there are various advantages for undergoing a court-assisted restructuring. Below are a few examples. First, moratorium, which means a stay in creditors' action, which allow the company to have the time to undergo the restructuring. Second, majority instead of all creditors' approval is required, and in many cases, shareholders' consent is not required, which means more flexibility and a higher chance of approving the plan. It also provides a more transparent forum for multi-party negotiations. Once the company is in some kind of court-assisted restructuring process, there will be fewer chance of lender liability actions and also less risk to directors on insolvent trading. Lastly, a court-assisted restructuring could be recognized by the foreign court, which is another advantage if the company has exposures in multi-jurisdictions. As there is no tailor-made statutory corporate rescue mechanism in Hong Kong, the current solution for implementing a court-assisted restructuring is by way of a scheme of arrangement. With provisional liquidators having been appointed to the company due to a risk of asset dissipation, the provisional liquidators may be granted the powers by the order to explore corporate rescue options. Here is a recap of the 4 stages to the scheme process that we have discussed in webinar 2. The first 2 stages are the most important, the proposal and completion of the proposal stage, where a restructuring plan is formulated and buy-in from the various stakeholders. This involves a lot of the negotiations and analysis to ensure each class of the creditors or members understand the pros and cons of the scheme and would vote in favor of it. Once the scheme is approved by the creditors, which is 50% in number and 70% in value, it has to be sanctioned by the court. Once it is sanctioned by the court, it will bind all the creditors, no matter whether they vote for it or not. The provisional liquidators or scheme administrators would then implement the provisions of the scheme. Once the scheme is implemented and completed, the scheme administrator will file a notice with the Register of Company stating that the scheme has been concluded. As mentioned before, one of the key criteria for a provisional liquidator to be appointed is that the assets are in jeopardy. For listed companies, when their listing status is in jeopardy, can be a valid basis upon which to appoint a provisional liquidator. In the Replus Holdings Limited case, it was held that the company was clearly insolvent and the most valuable asset was its listing status, which was in serious jeopardy. Thus, the appointment of a provisional liquidator for the purpose of submitting a viable restructuring proposal was not viewed as a departure from the traditional basis of a risk of asset dissipation and was therefore permitted. In fact, in Hong Kong, most companies which have utilized court-assisted restructurings are listed companies, as it usually involves more assets and creditors, so a more formalized way of restructuring would benefit all the parties involved. Also, due to the time and cost involved, it would be a company of substantial size and assets, like a listed company, to be worth restructured under the scheme of arrangement regime. In the next session, we would like to recap on the appointment of offshore light touch provisional liquidators. As discussed in webinar 2, the established practice of utilizing offshore provisional liquidator appointments to implement a corporate restructuring plan is explicitly allowed in these offshore jurisdictions, which is very different from the case in Hong Kong. Such provisional liquidator appointments are called light touch provisional liquidators, while the directors still remain in the day-to-day control of the affairs of the company, and the provisional liquidators are granted with limited power necessary to contemplate a restructuring plan. Most importantly, the stock trading would not be suspended as a result of the PL appointments. In order to implement the restructuring in Hong Kong, the light touch PLs would obtain a letter of request from the offshore court to request the Hong Kong court grants a reciprocal recognition of the offshore provisional liquidators' appointment and powers in Hong Kong, such that a moratorium on the creditors' actions will also be in place in Hong Kong to set the scene for the light touch PL to explore restructuring options for the listed companies. We have so far discussed various formal and informal restructuring options and their regulatory implications. In this session, I would like to highlight when a distressed company may become unsuitable for listing. When a listed company is facing severe financial difficulties, or where it has been forced to liquidate or dispose of its material assets, then the suitability of the company to remain listed may be questioned, in particular when its sustainability is in doubt. Further, it is likely that the share price may be materially suppressed, and this may cause it to become a shell company, which is susceptible to speculative trading and unnecessary volatility. In some more serious circumstances, the stock exchange may commence procedures for delisting the company if it believes that a fair and orderly market for its share cannot be maintained. Some related listing rules are set out in the following slides. In particular, under Rule 1324 of the listing rules, an issuer must have a sufficient level of operations and assets of sufficient value to warrant its continued listing. And in this regard, the stock exchange will require the company to have a viable and sustainable business. Some characteristics of the issuers, which may be viewed as having been in breach of Rule 1324 of the listing rules, include where they are in such financial difficulties which may seriously impair their ability to continue its business, or which has led to suspension of some or all of its operations, and or where they have net liabilities as at the balance sheet day, that is, when its liabilities exceed its assets. Further, under Rule 1482 of the listing rules, where after completion of various disposal of assets, the assets of the listed company consist wholly or substantially of cash and or short-term investment, including any securities which may be readily converted into cash, then the stock exchange will not regard the company as suitable for listing, and trading of its securities will be suspended. In order to resume trading and avoid a delisting, the relevant company must submit a resumption proposal to the stock exchange with actions it intends to take to remedy the issue. Paragraph 6.04 of the listing rules provides that the continuation of a suspension for a prolonged period without the issuer taking adequate action to obtain restoration of listing may lead to the exchange cancelling the listing. So what does that mean? That means unless the issuer proactively deals with and addresses its non-compliance as soon as it enters into the trading suspension territory, it is in the real risk of losing its listing status. This is where the appointment of a financial advisor as an independent party and as an added resources to the issuer is invaluable to ultimately assess the business financial needs and the most appropriate capital structure for the business going forward, and also come up with a plan to restructure its affairs to bring it back to financial health so that the trading of shares can be resumed. Failing which, the exchange will follow a 4 stages delisting procedures after trading suspension, which will take a total of 18 months, with 6 months at each of the stage 1 to 3, and delisting occurring at the end of stage 3, if no resumption proposal is submitted or time extension is granted. For stage 1, the issuer is required to make quarterly announcement of its development and progress in fulfilling resumption conditions in order to meet the sufficiency of operations obligations under Rule 1324. At the end of the 6-month period, the exchange will determine whether it is appropriate to extend this initial period or proceed to the second stage. During stages 2 and 3 of the delisting procedures, the exchange will further require the director to submit monthly progress reports. At the end of the period, the exchange will consider the issuer's proposal and determine whether it is appropriate to proceed to the next stage. If no resumption proposal have been received in the end of the third stage, the listing will be cancelled. And an announcement will be made by both the exchange and the issuer. The issuer may seek for an extension of each delisting stage. However, the granting of such extension has become rare in recent times, meaning that the issuer and its financial advisor will have to work on a strict 18-month time frame to complete a restructuring, fulfill resumption conditions, and resume the trading of the issuer's share. As discussed earlier, due to the very strict delisting procedures implemented by the exchange, there is real risk of the listed issuer losing its listing status unless it proactively deals with and addresses its non-compliance with Rule 1324. Where there is a viable existing business, no matter in whole or in part, the role of the financial advisor to the issuer is to do all the things necessary to help the resumption of the trading of the shares by resolving existing business issues within the 4-stage delisting process. This includes, first, reviewing the company's financial position, projections, and formulate a turnaround plan. Details have already been discussed in the webinar 2. Seeking for and identifying an appropriate white knight investor to implement the turnaround plan. Publishing all the outstanding financial results with any concerns raised by the auditors being addressed. Reporting to the Hong Kong Exchange on the issuer's efforts and progress to restructure its business, and negotiating with the stock exchange on the extensions to be granted at the end of the various stages of the delisting process until a resumption proposal is accepted. And finally, do all the things necessary to submit an adequate resumption proposal to the exchange. Where other restructuring options have failed and the listed company is facing serious cash flow issues or even risk of insolvency, then it may need to consider more drastic options, and this may include raising substantial amount of capital from investors, sometimes coupled with the injection of assets to support the sustainability of the business. Different from the offerer in a hostile takeover, such investors, sometimes referred as white knight, will acquire a substantial amount of shares of the company with the support and cooperation of the management. From a regulatory perspective, if it can be shown to the SFC that the company is in such a serious financial position that the only way it can be saved is by an urgent rescue operation involving the issuance of securities to the white knight, then the SFC may potentially waive the general offer obligation that would normally be triggered when it requires over 30% voting rights in the listed company. The granting of such waiver from the SFC is subject to full compliance with various requirements in the whitewash guidance under the Takeover Code. And this would typically include the obtaining of approval from at least 75% disinterested shareholders. However, if the SFC can be satisfied that the urgency of the rescue would make it impracticable for the rescue proposal to be submitted for approval by the disinterested shareholders, and it is satisfied that the proposal is equitable to the existing shareholders, then the SFC may also dispense with the requirement of obtaining the shareholders' approval under the whitewash. In some cases, the white knight may wish to inject businesses and assets into the listed company, and this may potentially give rise to reverse takeover implications under the listing rules. We will in the next few slides discuss what is meant by reverse takeovers and the relevant regulatory implications. But first, what would a reverse takeover process typically involve? It involves, first, a capital reorganization. This includes share consolidation, cancellation, or capital increase. Second, acquisition of the investor's business under the RTO regime. Third, receive the proceeds from open offer and subscription. Fourth, apply the proceeds to settle the creditor's claims and the professional fees. Fifth, a scheme of arrangement will then be implemented to release the listed issuers from the remaining creditor's claim. And then, finally, the trading of the listed issuers' shares will be resumed after the restoration of public float. Reverse takeover is defined in Note 2 to Rule 1406B of the listing rules, and the following transactions are normally recognized as reverse takeovers: an acquisition or a series of acquisitions of assets constituting a very substantial acquisition which will result in a change in control, which is defined in the takeover codes of the listed issuer. Acquisitions of assets from a person or group of persons entered into by the listed issuer within 36 months of such person or group of persons gaining control, again as defined in the takeover codes of the listed issuer. If the stock exchange considers acquisitions as a reverse takeover, it will require the application of all the new listing rules requirements on the business and assets being acquired, including appointment of sponsor to carry out extensive due diligence, registration of a prospectus, as well as vetting of a listing application, which may be considered by any white knight as onerous and undesirable, as this process often takes up to more than 6 months, with substantial devotion of resources on professional parties. The stock exchange will also consider the following factors in determining whether there is an attempt to circumvent new listing requirements. These include considerations as to whether the acquisitions would lead to a fundamental change in the listed company's principal business rather than part of its generous business expansion, or diversification plans or strategies, and whether the assets being acquired would be of such quality that it could meet the listing rules requirement if they were to be listed. If the business to be acquired or the enlarged business could individually meet the new listing requirements, and the stock exchange is satisfied that the acquisitions are not an attempt to circumvent new listing rules, then it may possibly treat the transaction as an extreme transaction rather than a reverse takeover. In such circumstances, the transaction will not be treated as a new listing and only a financial advisor is required to be appointed to perform due diligence on the acquisition target and certify the accuracy of the circular. More detailed requirements applicable to an extreme transaction are set out in the slides, which I will not go through in details due to the time constraints today. The reverse takeover framework under the existing listing rules is a consolidation of a number of previous guidance letters into formal listing rules following a consultation paper on a backdoor listing. The intention of such rules is to disallow backdoor listings involving large-scale issuer of securities for cash, which will result in a change in control or de facto control of the listed company. Such amendments led to the current two-tier categorizations of transactions, where there is a change in control and injections in assets, namely a reverse takeover requiring full compliance with the new listing requirements, and extreme transactions, whereby less onerous requirements apply. Due to the more formalized framework, RTOs have faced more limitations and hurdles to succeed in recent times due to the SFC's tightening of its rules on the new business and asset requirement to meet the listing standards, as well as being less flexible in granting time extension to each delisting stage to allow time for the white knight to be sourced and the RTO to be negotiated. Due to the high uncertainty in the RTO process, we see limited successful cases since the end of 2019. However, the amended reverse takeover rules are not intended to restrict legitimate business activities of the listed company. But nevertheless, these rules and the implication must be considered in detail in evaluating any white knight or restructuring plans if acquisition of substantial business or assets are involved. Unfortunately, where the company has very limited operation or asset, or is in the brink of insolvency with shell characteristics, then the stock exchange would likely treat the relevant acquisition as reverse takeover rather than extreme transactions. Other than these practical hurdles to be aware of, it should also be noted that the appointment of a provisional liquidator to list the issuer in financial difficulties on the basis that its listing status is its most valuable asset and is in jeopardy has not always been successful. In the next slide, we will discuss the recent case, the China Huiyun Juice Group Limited, which is a Cayman Incorporated Hong Kong listed company. The company is insolvent and the shares have been suspended from trading since April 2018. There is no asset in Hong Kong, and all the assets and operations are in mainland, held through the BVI intermediate companies. In this case, the Hong Kong Court did not grant an order to wind up the Hong Kong listed company, as it was highly unlikely that the listing status would have any residual value. It is because, at the time, the winding up petition was presented. The issuer had already been suspended trading for 16 months, and the petitioner could not demonstrate that an incoming provisional liquidators or liquidators will be able to rescue the listing status. In other words, the China Huiyun Juice case is very different from the Repress Holdings Limited case. The value of it is a combination of factors, including the tightening listing rules, and also it was too late to initiate the restructuring process. Hence, it is very important that the listed company proactively seeks for restructuring once there are the signs of financial distress. We would recommend the discussion of any white knight rescue to start before the suspension of trading. And this is the end of today's webinar, and I hope you all enjoy it. Now I will pass it to Julia. Thanks, Julia.
Thank you, Connie. So as Connie said, that brings us to the conclusion of the formal part of our presentation. And if you have further questions for any of us, please email me at juliacharlton@charltonslaw.com, and I'll do my best to coordinate an answer for you. Thank you for joining us today, and we do hope that we'll see you in future webinars. Have a good evening.